Okay, we're ready. Ready when you are. Good afternoon, ladies.
Good afternoon.
Ms. Clifton?
This is case number 180149447 Doris Kennard versus Liberty Mutual Insurance Company.
Good afternoon, counsel. Appearances for the record.
Good afternoon, Ashley Bricker on behalf of the plaintiff Doris Kennard.
Good afternoon, Haley Bavel on behalf of defendant Liberty Mutual.
Okay. Ms. Bayfall, this is Liberty Mutual's motion, so you may proceed.
All right. This is defendant's motion for summary disposition brought pursuant to MCR 2.116C10 based on coverage. Plaintiff brought this suit seeking PIP benefits following a motor vehicle accident that occurred 11/19/2017 in Erie County, Ohio. At the time of the accident, plaintiff's address was 3919 Elite Street, Bowie, Maryland. Plaintiff is seeking benefits under a Maryland Liberty Mutual policy, which had the Bowie, Maryland address listed as the policy address and residential address. This Maryland policy had policy limits of $2,500. As of February 20th, 2018, Liberty Mutual has paid $2,500 in relation to plaintiff's medical expenses, and therefore defendant maintains that plaintiff's benefits have been exhausted and no further funds are available. Following the accident, plaintiff spoke with the claims adjuster advising Liberty Mutual that she was staying with her sister in Detroit until after the holidays. Further, when plaintiff sought treatment, she provided the Maryland address to the providers. For example, she told ER at Henry Ford that she lives in Maryland and gets her medications filled there, and that she will be in Michigan for just 2 weeks. She also told Fisher Titus Medical Center that her current address is the Maryland address, the Bowie, Maryland address. And she also told treaters at Michigan Head and Spine that she was involved in an accident when traveling from Maryland, where she lives, to Michigan, where she's eventually moving. Also involved in this motor vehicle accident was David Martin, Miss Kennard's significant other at the time of the accident. He was deposed on November 25th, 2019, and he testified that when asked where he was living at the time of the accident, he stated that he was living with Doris Kennard in Maryland. He further explained that at the time of the accident, they were traveling from Kennard's house in Maryland to Detroit. He said that she was in the process of selling her home in Maryland and they were planning on returning to Maryland after visiting family in Detroit for the holidays. He said at the time of the accident, Miss Kennard still had keys to the property, or still had keys to the Maryland address and property at the Maryland address. And lastly, Mr. David Martin filed suit for PIP benefits under Miss Kennard's policy, which was before Judge Dana Hathaway in this court. This exact MSD was brought before Judge Hathaway and was granted on April 21st, 2020.
Ms. Bugart?
Yeah, just in response, we believe this is actually a Michigan policy because Ms. Kennard, we've attached an affidavit saying she wasn't living in Maryland at the time this accident occurred. She had moved to Michigan in October of 17, which is about a month before this accident occurred. When the accident occurred, she was still moving some of her personal belongings from the Maryland home to Michigan, but she had already abandoned living in Maryland, if you will, and was in the process of making sure she had everything in Michigan. She informed them that she was in Michigan in October when she moved to Michigan. She had them mail her stuff in Michigan. And she had a storage unit in Michigan. And I think overall, just domicile is really the issue here, and as to whether it's a Maryland policy or a Michigan policy. And domicile and residency are generally always questions of fact. And I think there's clearly questions of fact here for the jury to determine whether she was really residing in Maryland when this accident happened or in Michigan. I mean, I think we provided a lot of evidence showing the questions of fact, and that they all lean towards that she was in Michigan when this happened, when that her residence was in Michigan when this vehicle accident happened. You know, they point to some medical records, but if you go through their claims file, and I attach them to my motion, the billing forms from those providers from Michigan Head and Spine state the Walker address in Van Buren Township, which is where she informed the adjuster that she was staying when she initially moved from Maryland to Michigan. So there's a question of fact there. There's dates and addresses in Michigan that would coincide with her living in Michigan and being domiciled in Michigan, and Liberty Mutual knew that she was in Michigan when this accident occurred. As to, in response to the testimony with her significant other, if you look at the overall testimony of his deposition, I think it's clear that they were moving and he was going back and forth with her, moving her stuff. But when you asked him where he resides, he said, you know, if things weren't going on with her, his address was here with his sister. He always used his sister's address in Detroit. He had his sister's stuff he had his stuff at his sister's house in Detroit. So I think it's clear that he never resided with her in Maryland. For them to make that leap, I think, is a stretch as to Mr. Martin to tie Ms. Kennard to Maryland. And lastly, this motion was, the response was due. They had filed this motion, and initially in Mr. Martin's case, it was denied. And then later they refiled it. Judge Hathaway did grant it, but she didn't have oral arguments when she granted it in April. So
it's really relevant what Judge Hathaway. Yeah, I place no stock in that. Whatever I rule is ultimately my decision.
Right. So my ending point is just, I think it boils down to question of fact as to domicile residency. And I think she was living in Michigan at the time of the accident, or there is at least enough evidence that there is a question of fact as to her domicile. And I don't think this case should be dismissed based on that.
Ms. Bavon?
Yeah, this is nothing additional to add.
You know, I don't think there's a question of fact here. It's not a domicile issue. You look, you know, it's a Liberty Mutual policy, which was written in Maryland. She, her license said Maryland, and everything she was in the quote unquote process of, you know, that doesn't take it away from the fact that she was in Maryland. Her policy was in Maryland. It was written in Maryland. You know, she didn't change it. You know, when she got here, I'm sure she did change it. You're talking about the services or the medical services that were provided. That was after the accident took place. That, you know, had no bearings on what was going on at the time of the accident. At the time of the accident, her residency was in Maryland. It's clear it was in Maryland. She had a Maryland policy. Even taking evidence in light most favorable to the non-moving party, the court doesn't find that it is an issue of domicile, because it's clear everything that she has, she had her proof that she was a Maryland resident. She may have made a transition, but all that's irrelevant after the fact. At the time of the accident, she was a Maryland resident. That being said, the court is going to grant the motion for summary disposition. Ms. Baywell will look for you to present an order to the court, and that will resolve this case. So it will dismiss this matter. So we'll look for the order.
Okay, thank you.
Thank you.
Take care.
Okay, you too.
Bye.